Hi, my name is Samantha Lyneham and I'm a Principal Research Analyst at the Australian Institute of Criminology, where I lead the Human Trafficking and Slavery Research Program. In this presentation, I will be discussing the findings of research that we undertook to understand the level and points of attrition among human trafficking and slavery cases through each phase of the criminal justice system. Briefly, when I refer to human trafficking and slavery, I'm talking about the recruitment of people via coercion, threat, or deception for the purpose of exploitation. Exploitation is defined as slavery, servitude, forced labour, forced marriage, and debt bondage. Trafficking is the process of bringing a person into a situation of exploitation. However, the various types of exploitation can also be standalone offences. Globally, we know the investigation and prosecution of human trafficking and slavery cases is extremely challenging. Over time, there has been an overall increase in the number of prosecutions, but the absolute number of convictions remains remarkably low, especially when compared to the estimated number of victims. The International Labour Organization estimates there are more than 40 million victims worldwide, and that figure has been increasing each year. Yet, United Nations Office of Drugs and Crime data from 2016 shows that on average, 40% of countries secure fewer than 10 convictions per year, and 15% of countries secure no convictions at all. What this looks like in terms of global attrition statistics is that there is an overall attrition rate of 84%, with most attrition occurring between when a prosecution is commenced and when a conviction is secured. In comparison, in Australia, as at the 30th of June 2019, 24 offenders were convicted, which is about 1 to 2 convictions per year, and 462 victims were referred to the government's Support for Trafficked People program, which is about 30 victims on average per year. This study aimed to identify the points of attrition in the criminal justice process and identify the challenges that police and prosecutors face when investigating, prosecuting, and attempting to secure a conviction. We analysed quantitative data from the AFP and Commonwealth Director of Public Prosecutions, which were categorised into 3 phases of the criminal justice process: investigation, prosecution, and court, and which were related to cases, defendants, and offences. These data were analysed for matters received between December 1999 and June 2017. We also undertook 22 qualitative interviews with investigators, prosecutors, immigration officials, and victim support providers to elicit a range of information about the familiarity and complexity of human trafficking and slavery legislation, collaboration between police and prosecutors in the referral, preparation, and pursuit of matters, the role of evidence and victim testimony, factors influencing decisions to investigate, charge, and prosecute, reasons why a case did not proceed, the characteristics of cases that were more likely to proceed, and the extent to which other charges have also been pursued in combination with human trafficking and slavery charges. There are 2 key limitations of this data. The AFP and CDPP datasets are unmatched, so we can't track an individual case or defendant from the start of an investigation to the end of a prosecution. We were also unable to remove ongoing cases from the AFP dataset, whereas the CDPP dataset only included finalised cases. Therefore, we couldn't calculate overall attrition only from the point at which charges were laid. Investigators and prosecutors assess a case at each stage of the criminal justice process and make decisions about whether or not to proceed based on the public interest and the likelihood of securing a conviction. Criminal justice processes are not necessarily linear, and there are many points where attrition can occur. Although you won't be able to see the detail in this figure, I've provided it as an overall visual reference for the processes that I'll be talking about in this presentation, starting with matters being referred to the AFP, charges being laid, preliminary court processes including entering a plea, and finally court outcomes. Of the 841 cases referred to the AFP between 1999 and 2017, we know that about half progressed to an active investigation phase. We can't calculate attrition at this point because these figures include ongoing matters where we didn't yet know whether or not they would proceed to an active investigation. The other important thing to note is that there has been a substantial increase in the proportion of matters related to forced marriage, which was criminalised in 2013. Due to the nature of forced marriage primarily being perpetrated by family members and therefore the reticence of victims to prosecute, the AFP focuses on preventing forced marriages from occurring rather than collecting evidence to support a prosecution. There are a range of other reasons why a case might not progress to an active investigation phase, including no offence being identified, insufficient evidence or the victim withdrawing their complaint, the matter not being related to human trafficking or slavery but another crime, and the matter being referred to another jurisdiction. Following on from an investigation, the AFP referred 62 cases involving 93 defendants for prosecution, and as a result, 52 defendants were charged with 169 offences. So in this first phase of prosecution, there was attrition of 44% of defendants. Half of defendants were charged with slavery and servitude offences, 1/3 were charged with human trafficking offences, and 1/3 were charged with migration or passport offences. This means that defendants were more commonly charged with offences that sit on the more serious end of the scale of human trafficking and slavery offending, but they were also commonly charged with alternative offences, which generally carried a lower penalty. All defendants who were charged progressed to a committal or summary hearing, where the defendant can enter a plea and where the judge or magistrate decides whether a case has been established and can go to trial. At this point, 26 defendants and 71 offences were dismissed due to insufficient evidence or because the prosecution decided to withdraw the case. Of the 71 charges dropped at the committal phase, most related to the more serious offences of servitude, slavery or human trafficking, which made up about 60% of offences that were withdrawn. At this stage of the prosecution process, there was also attrition of 19% of defendants. From there, 33 defendants who entered no plea or a plea of not guilty were committed to trial, and 11 defendants who entered a guilty plea were convicted. Overall, 25 defendants were convicted of 51 offences as a result of pleading guilty or being found guilty at trial. 8 defendants were acquitted of 11 offences, and 16 defendants had 35 offences withdrawn throughout the trial process. Between the plea/trial phase and the finalisation of court outcomes, there was attrition of 40% of defendants. So what does attrition look like overall? Well, there was an overall attrition rate of 73% between the number of defendants referred for prosecution and the number of defendants who were convicted. This figure is remarkably similar to the global attrition rate of 75%. Interestingly, the conviction rate was higher than the rate of acquittal and withdrawal once a prosecution was commenced. So in other words, the majority of matters were withdrawn or discontinued before reaching the plea or trial phase. However, if a matter progressed to that phase, then there was a 60% chance of securing a conviction. However, at the offence level, the more serious charges of human trafficking and slavery had a lower conviction rate than alternative charges. Human trafficking and slavery offences comprised the largest proportion of charges, about 60%, but they comprised the smallest proportion of convictions, about 40%. Overall, the prosecution attrition rate for human trafficking and slavery offences was 80% compared to 54% for alternative offences. Child sex offences were most likely to be proven, about 90%, followed by migration and passport offences, just over 50%. These were the only offence categories to have a greater than 50% success rate, excluding the single forced marriage offence. Among the human trafficking and slavery offences, slavery was most commonly proven, about 30%, whereas human trafficking and servitude charges were least likely to be proven, about 15% each. So Australia's response to human trafficking and slavery has a strong criminal justice focus. However, both the global and Australian criminal justice response has actually been historically weak, and there have been far fewer prosecutions than expected based on the estimated number of victims. Past research has indicated a number of reasons why these investigations and prosecutions have been so challenging internationally, and our interviews with Australian practitioners confirmed many of these challenges. Importantly, the challenges are not necessarily unique to human trafficking and affect many different crime types. However, it does appear as though the challenges may be exacerbated in the context of investigating and prosecuting human trafficking and slavery offences. Victim identification and cooperation is consistently identified as a challenge for these cases. However, in contrast to the international literature, Australian practitioners commented on the strong desire of victims to cooperate, at least initially. Therefore, front-end attrition was not thought to be explained by a lack of victim cooperation, but rather the decisions of criminal justice practitioners to withdraw the case early in the process for other reasons. However, even when victims were eager to participate, investigators identified complex trauma, lack of English, and cultural and institutional issues related to mistrust in police as barriers to effective victim engagement. Practitioners also perceived cooperation to be dependent on the type of exploitation, as well as the relationship between the victim and the offender. Labour exploitation victims were perceived as being more likely to cooperate as a result of being motivated to recover lost wages. All victims, regardless of the type of exploitation, were perceived as being less likely to cooperate if the perpetrator was a family member, and this was especially the case if the victim was a child. The second reason for attrition related to victim credibility and evidentiary difficulties. Criminal justice processes rely heavily on victim testimony, which means that problems with victim engagement often lead to unsatisfactory evidence. Victim evidence has found to be inconsistent and contradictory, which is generally related to victims' experiences of trauma and fear. And victims have been viewed as dishonest in order to obtain a visa to remain in Australia. There were also perceived issues with delays in collecting evidence and interviewing victims as a result of the 90-day recovery and reflection period afforded to victims before being required to engage with police in order to receive support through the government's Support for Trafficked People program. Further, the human trafficking and slavery legislation was considered more complex than other crime types due to the number of different elements that need to be proven and imprecisely defined concepts such as coercion, vulnerability, and taking advantage of another person. Few cases also mean there is a lack of case law to provide guidance on evidentiary requirements and how legal concepts have been tested. This means that prosecutors lead with or include alternative charges that they're more familiar with, which have been tested in court previously, and which have a higher likelihood of conviction. Finally, Australian criminal justice practitioners felt it was difficult to develop specialisation in the area of human trafficking and slavery as a result of limited training, experience, and exposure. Concerns were raised about staff attrition, often as a result of mandatory rotations, which results in loss of consistency and qualification across the area and necessitates frequent rebuilding of multi-agency relationships. This becomes particularly problematic when cases take 2 to 3 years on average to conclude. Further, federal crimes typically do not involve traumatised and vulnerable victims, so practitioners felt that specialist training was required to effectively engage with this complex and unique victim cohort. If you would like to read the findings in full, the report is available online at aic.gov.au.